We will have a very short second round. Can we limit only to one question, the colleagues who want to ask a question? I have on my list Senator Baker, Senator Milne, and Senator Wallace. Senator Baker.
Yes, thank you, Chair. I just have one question. It's a technical question for the witness, and it's something that has bothered me for some time, the general question of it. I just noticed at Section 6 of the bill, it says Schedule 1 to the Act is amended by adding the following after item 18. And then it says 19, and if you go down to 8 on the English side, I won't try to pronounce it. It adds N-methyl-3, 4-methyl-lexadoxamphetamine, and then it goes on and on and on. Now, looking at that, that seems to me like ecstasy. Okay? Now, you have behind you police officers. Well, I've seen charge documents like that involving other people. But now, you have police officers behind you, and they usually try to put in brackets there, in that case, ecstasy, so that I suppose the person charged will know why what they're being charged with. But when that comes to a judge says, well, the word ecstasy has no value in law at all. It's nowhere in the Controlled Drugs and Substances Act. What's in the Controlled Drugs and Substances Act schedule is exactly that, what's there, listed in 8. And if a comma is missing, or a letter is missing, they usually throw it out. Because, well, I've read a lot of case law on it. And I'll tell you that it's not rare that you see a case thrown out because it wasn't identified properly because the judge is not a chemist, usually not a chemist. But in any other jurisdictions, is there a simpler way of doing this on a charge document and listing it in the schedule? Is there a simpler way, or do all other nations in the world use the chemical composition of what's there? And lastly, since you're lifting ecstasy up to Schedule 1, when you look at 4.1 in the Controlled Drugs and Substances Act, there's quite a difference in the penalty if you're in Schedule 1 or if you're in Schedule 3, which is where ecstasy is now. So is there a public campaign going to take place to say to all of those young people who go to these raves using ecstasy, look, this is now going to be, now you're going to end up with a more serious offense if you're ever caught with one of these pills? So there's two questions there. Is there a better way of doing this? And secondly, will the young people be warned? Yes.
As to the question, is there a better way of doing it? You asked whether or not other countries were doing it the same way, and I believe that in some countries, yes, particularly OECD countries that have very well-developed legal systems and so on. Other countries may or may not do it. In fact, after I read the transcript when the minister testified, I noticed that there was an interest in what is happening internationally with respect to minimum penalties. So I did a little bit of research, and I looked at the way that other countries formulated their or structured their narcotics legislation, and often the chemical breakdown as it is here, the analogs and the derivatives are not listed. They will go with just amphetamine and so on and so forth. So that level of detail is not found everywhere, but it is found in many countries. It is also found in the international treaties to a certain extent.
Okay.
So it's not that unusual. Mm-hmm. And while honestly, I cannot for sure say that when a charge is laid in the case of ecstasy, only the word ecstasy shows up. The whole thing shows up, but in brackets. The whole thing will show up in brackets. The RCMP officer put ecstasy so that I know that if there is a slight error in the charge, that the judges will allow amendments to be made.
Well, some judges do. I think the RCMP might say something different. But anyway.
Merci, Senator. Senator Mill.
Thank you, Mr. Chair. Monsieur Saint-Denis, if I can remember exactly what Senator Angus said, he quoted the minister as saying this bill will not make the streets more safe. And you said this bill is not going to increase our prison population.
It wasn't the minister who said it won't make them more safe. He suggested it would. But the answer in writing from the criminal lawyer was saying this won't make them safe.
So, number one, why are we looking at this bill at all? And secondly, why on earth is this bill written as though it seems to be proposing that drug courts are an option for those who may be charged or who have been convicted, but their sentencing can be delayed if they go to a drug treatment court that's approved by the Attorney General. And the Department of Justice doesn't recognize the validity of these drug courts. You say they are just experimental.
I don't believe I said that we didn't recognize the validity of them. I said that we have not embarked on a program of expanding them, primarily because the courts are still in an evaluative stage.
Are you evaluating them? Are you gathering data?
There is evaluation, not programs, but evaluation stages for each court, and we hope to be able to gather and collate all of that information and allow us to make some kind of a decision as to whether or not they are beneficial, whether they are beneficial, and so on and so forth.
How long have you been gathering this data, and how long is it going to take? Sorry, that's more than one question.
I can't tell you. I can tell you that we've been collecting data from the Toronto and Vancouver courts for a good long time now.
Yes, you should be coming to a conclusion sooner or later. Sooner, I hope.
Well, the thing is that the courts where they're situated tend to represent different realities. The court in Vancouver deals with a clientele that is, I would suggest, fairly different than the clientele that they have in Ottawa, for instance, or in Toronto. So, and there were initially, at least with the Vancouver court, some issues concerning the evaluative process. So I think that has caused delays. But the thing is that the evaluation of one court in one city might not be conclusive and determinative of the courts in all cities. And so we need to gather more information, is what I know.
And on and on and on?
Well, hopefully not. Hopefully that there will be a point where we'll be able to say this makes sense and we should expand, or this makes no sense and we shouldn't, or...
But just to complement that, would it be possible to have, for the committee to have access to read the evaluation criteria that you're using in your process evaluating the drug courts?
Honestly, I can't tell you, but if you will just bear with me one moment, I can check with my colleagues who
please.
Are here. Something we can say? Well, I'm told that in fact the evaluation framework will be put up on the Justice website.
Good.
And that that there will be some results, some information that will also be posted on the website.
Do we have an idea when that will be done?
Soon is what I'm told. So a specific date, I don't think, but soon.
Well, we intend to give this bill a thorough review, so we may have time to see that posting before the end of the